on a number of occasions throughout a number of decades that forfeiture itself, or in general, is a highly disfavored form of punishment. So when we view these Eighth Amendment cases,
let me just ask you right there. You raised an Eighth Amendment claim, but the Ohio Constitution also has an excessive fines clause. In at least historically, the U.S. Supreme Court case law has not been all that favorable to defendants on excessive fines. Why not? And we've never really developed what our excessive fines clause means. So why not bring a claim under the Ohio Constitution? Why do you stick just to the federal Constitution?
Well, as you mentioned, the law isn't really developed very much as far as the state is concerned, which I think is why the court maybe agreed to hear this case.
But if no one ever raises a state constitutional excessive fines claim, the law will never be developed in Ohio.
I guess you're right about that, Your Honor. But I think the reason why I brought it under the Eighth Amendment is because there's been so much recent activity in the country on the Eighth Amendment with the Ohio Supreme Court, with the state of Indiana and the Timms case, and the case law, the body of case law federally on the Eighth Amendment. There's much more to work with than there is in the state of Ohio. There actually isn't very many forfeiture cases, in the appellate courts around the state, which is one of the issues I'm hoping that this decision will address eventually.
Didn't the trial court also consider Article 1, or consider Article 1, Section 9 of the state constitution when it looked at the Eighth Amendment concerns as well? I thought that was part of what was before the trial court.
It may have referenced it.
Counsel, if you can hear me, we're having technical difficulty with you.
Sorry, are you there, Chief Justice?
Yeah, you froze for the last, we didn't hear what you responded to Justice Bruner.
Oh, I apologize. The trial court's opinion did reference the federal and state case law, but it didn't necessarily focus on the Ohio Constitution per se.
But I think what I was trying to get to was, I'm sure you're using the Eighth Amendment of the U.S. Constitution because of the plethora of case law there, but because the trial court actually referenced it, I mean, it's something we can deal with if we would want to reference that. In our case, I don't think you waived it, do you?
I didn't waive it, no, and you're absolutely right. And as the court's aware, you can provide more protection under the state constitution than even the federal law provides. It's certainly up to the court, and hopefully the court does do that in this case, based on the issue we have on this as applied challenge.
Thank you.
So just to talk briefly about the trial court's opinion, we have a couple of issues with the way the trial court made its decision. First, its reliance on this State versus Zeipel case, I think, is very problematic. Number one, because it is so old and it predates most of the new case law in this area, especially with regard to the federal court. It's also very distinguishable on its facts. So that was the case that the court relied on the most, and was almost the very first thing the court said in its analysis of this issue. The court also relied on this State versus Kish case, which the court did state that it had a limited multi-factor test that it used. But the Kish case is also problematic for a number of reasons. Number one, in the Kish decision, it states that all of the factors that it listed are essentially equal, that none of them have any more weight than the other. But if we're going to consider at least the federal court decisions in this area, the cases cited in my brief stand for the proposition that some of the factors are going to hold more weight than others. So specifically in the Sixth Circuit Court has said that the forfeiture to fine ratio is going to hold a lot of weight, and perhaps more weight than any of the other factors. So the trial court's reliance on Kish holding all the factors equal would be problematic and erroneous, in my opinion.
Isn't this case a little different than most forfeiture cases, or at least, I guess I would think the typical forfeiture case is, someone has drugs in a house, and the federal government or the state government seizes the house, and you look at what the proportionality obviously matters a lot there, even maybe transported in a vehicle or whatever. But here, it seems that part of the statute is, or part of the intent of the statute is that this defendant driving a vehicle is dangerous because he continues to refuse to follow the law about drunk driving. And what the statute does is, after so many offenses, it says, okay, we're going to take that dangerous instrumentality out of his hands, regardless of what kind of car he's driving. So doesn't that make this case a little different than some of those other cases where you're really just looking at whether or not the fine is proportional to considering the harm and what other fine they could have gotten?
Well, at least according to my research on this case, most of the forfeiture cases do involve drug trafficking and
right.
major drug trafficking.
Right, they involve major drug trafficking, but the point here is that this involves a vehicle which, at least in the legislator's judgment, is dangerous for the defendant to continue driving because he keeps driving drunk. And that's a little different than just saying, okay, we're going to seize your car because it happened to have drugs in it.
Yes, and that's true. But we need to be mindful of a couple things with respect to the legislature. Number one, on a third OVI, the legislature has made the policy determination that this is still going to be a misdemeanor crime, and it has set the maximum fine at $2,750. So viewing the totality of the circumstances, we need to consider the fact that this is still a misdemeanor, and that fact places some sort of upper limit on the amount of a forfeiture, amount of the vehicle forfeiture, as opposed to maybe a felony. And I cited in my brief the statute, the penalty statute for felonies of the first degree, which the maximum punishment is $20,000, or even a forfeiture on a felony OVI, the maximum penalty is $10,500. So this forfeiture in this particular case was $31,000. So that greatly exceeds both the felony OVI maximum penalty and the maximum penalty for even a felony of the first degree.
Well, counsel, so you're saying if this car was worth $1,000, we wouldn't be here?
Yes, that's true. The case law has well established that if
I understand that. However, this is the item that facilitates the offense. There's two things that facilitate the offense. One is the consumption of alcohol to the point where your client's impaired, and the other is to get behind the wheel of this vehicle. And as I think Justice DeWine said, the intent was to remove the means by which your client continuously breaks the law and endangers society and himself. And does that nexus and that intent not trump this argument about proportionality of dollars?
Well, the fact that it's a third OVI is certainly a relevant consideration on gross proportionality, but that question is actually a perfect segue into our 14th Amendment argument. And we need to consider.
But before you do that, there's been the argument that, okay, there's a suspension of the driver's license, but that obviously doesn't keep him from going to his vehicle. But aren't there intermediate steps before foreclosure, like ignition locks and things that could actually be placed on the vehicle so that he couldn't use it? Yeah, and I'm saying that because now you're going to get into the equal protection argument. And
yes, the legislature has given the courts the power to do a number of different things to prevent third OVI offenders or any OVI offender from driving. So we've got license suspensions. The court could order the vehicle to be immobilized in the driveway where it can't be driven. It could order alcohol monitoring. It could order interlock machines, alcohol monitoring devices in the car itself.
Counsel, were they ever employed before for your client?
Yes. So Mr. O'Malley received, number one, he received an administrative license suspension the day that he received his ticket. So right there, that took him off the road. And then once he had pled to the offense, he received a 5-year license suspension. So even if
what about in his previous DUIs? Was there any interlock or immobilization employed?
Well, on his second OVI, which I believe was quite a few years ago, there was a lot of distance between the second.
Well, we're looking at a 10-year window, so that's what we're stuck with. So
yes, we're stuck with that. But at least on a second OVI now, immobilization of the vehicle is mandatory for 90 days, and a license suspension would be mandatory, and limited driving privileges could only be granted if an interlock machine was installed on the vehicle. So
I asked what happened in the past, though.
Well, I believe he would have been subject to those same penalties.
So he's had an interlock before. He's had license suspensions. He's had these intermediate interventions to no avail.
He has, and that would be the case for any person who reaches a third or more OVIs. But we have Eighth Amendment implications here on the issue of forfeiture. So they're in a policy against forfeiture in this state. So we have to consider that the legislature needs to use alternative means other than excessive fines and forfeitures to prohibit people from committing certain conduct in the future. The Eighth Amendment takes certain policy choices off the table. And in this case, once we reach a forfeiture that's at a certain level, we just can't do it. It's just constitutionally prohibited.
So the forfeiture only goes to the car that was being operated?
Yes, the offender would have had to have been operating the vehicle at the time of the offense, and it needed to be registered in their name.
Nothing stops the individual if they have one other mode of transportation or 4 other modes of transportation. The state doesn't get to take those.
No, the state doesn't get to take all of their vehicles. So if somebody has 2 cars, they could certainly choose to maybe break the law and drive under suspension with their second vehicle that wasn't forfeited.
Nothing stops them from buying a second car.
Well, if you are
registering, I understand he can't register, but nothing stops him from buying a car.
No, nothing stops him from buying it. So I suppose they could drive an unregistered vehicle, which
nothing stops him, absent the license suspension, from borrowing a car and driving it.
That's true. That's true. So there's a lot of other means. If somebody's going to break the law, the fact that they got their primary vehicle forfeited is not going to stop them from doing so. So that's one of the arguments I made on the 14th Amendment as to why that's irrational, is because there's so many ways around that law that the forfeiture does not accomplish what the state thinks it's going to accomplish or wants to accomplish. Well,
counsel, do you have any data that would indicate what you're saying? Yes, there may be ways around it, but is there any studies done to show all these alternatives being employed by people who are similarly situated to your client?
I don't have any data on how many people are violating the license, the license suspension laws after they've had a vehicle forfeited. I don't know that data even exists, but we just know that practically speaking, it very easily can be done. And we just talked about a number of different ways that could happen. So I believe
you've used all of your time practically, counsel.
Thank you, Your Honor.
Thank you. Mr. Fisher.
Chief Justice O'Connor, may it please the Honorable Court. On July 4th, 2018, at 1:45 a.m. in the morning, the defendant appellant was stopped by a state highway patrol officer for erratic driving, marked lane change violation. He was asked to produce his driver's license and produce the credit card. He did not know his home address, and refused a breathalyzer. Subsequently, the defendant appellant pled no contest with a finding of guilt, with the full understanding under the law that the vehicle, the Chevy pickup truck, 2014 Chevy pickup truck, would be subject to a subsequent hearing on possible forfeiture. The court, separate from the no contest plea with finding of guilt, set a separate hearing date for the forfeiture hearing, conducted the hearing with the defendant appellant present with his counsel, full opportunity under due process of law to present evidence and testimony. The court, the trial court, Medina Municipal Court, pursuant to State versus Herald, employed the 7 criteria in State v. Herald and made a determination based upon the totality of all the circumstance, third OVI conviction under the statute with the recidivism provision enacted by the Ohio legislature to forfeit the car. The testimony at the hearing was that the defendant appellant paid $5,000 for the vehicle. He also testified that he put $8,000 of improvement, but there's nothing in the record other than the defendant's testimony to support that assertion. He then testified that the vehicle's worth $31,000 and that knew it was worth $39,000. And again, it's a 2014 truck that is.
Well, counsel, what wouldn't the state have moved to forfeit if he were driving a $150,000 car? Would the procedures have been any different?
They would not have been different, Your Honor. It would have been the same procedure. And I would strongly suggest that the burden of proof on the defendant appellant at the trial court level was preponderance of the evidence. However, there's no appeal of the trial court's decision that it was against the manifest weight of the evidence or otherwise. Instead, under proposition of law number 1, the defendant appellant is contesting the constitutionality of the forfeiture statute as applied, which requires a burden of clear and convincing evidence. So the trial court's decision is not before this honorable court this morning. What is before the honorable court is the constitutional issue as to whether or not the statute on its face is violative of the 8th Amendment and Article 1, Section 9 of the Ohio Constitution. And I would strongly suggest that.
Is it your thought that it would be unconstitutional as applied if he were driving a $150,000 vehicle?
I suggest not. I suggest not. That would be a matter for the trial court to take in consideration. And there's several factors, Your Honor, under State v. Herald that were examined in detail. Culpability of the defendant, gravity of the offense, relationship between the property and the offense, harm to the community, the fair market value of the property, intangible and subjective value, and hardship to the defendant. All those criteria.
But arguably, let's say the defendant had a car that was valued $150,000 and it was one of 3 vehicles he owned, as opposed to a defendant who had a vehicle that was worth, say, $2,500 and it's the only vehicle he owned. I mean, is it evaluated in relationship to, arguably if someone lost this vehicle that was the only source of transportation to and from work, et cetera, that's a hardship. If someone lost a $150,000 vehicle, that's a financial hardship if you've got 2 or 3 more.
Well, under the 8th Amendment, cruel and unusual punishment, excessive fine provision, if somebody can afford to drive a $150,000 car, then they can afford to forfeit it if they have 3 OVI convictions in 10 years, at least if the other criteria in State v. Herald are met. I would suggest that obviously the more expensive the car, the greater the disproportionate amount is between the $2,750 fine and the value of the vehicle. But again, it still would be subject to forfeiture under the law as established by the Ohio legislature with a strong presumption of constitutionality.
Thank you.
And again, in regard to Proposition 1, I believe again that it's clear and convincing evidence that the preponderance of the evidence standard, if the trial court is not before this court this morning based upon the proposition of law as submitted. In regard to the second proposition of law, the equal protection argument, that individuals that don't own vehicles are not subject to forfeiture under the recidivism provision in the Ohio vehicle intoxicated statutes is clearly wrong, because again, there's several examples in the statute of forfeiture separate from ownership, 4511.19 G1C5, also in 4511.203 C3C, there's forfeiture based on registration, which happens many times. If you lease a car, it's often registered in the driver's name. And again, that would also be applicable, as well as negligent entrustment under 4511.203 A4. So under proposition of law 2, I believe, again, the defendant appellant has not met his burden. And again, there is no equal protection argument, or at least valid, I would submit, valid equal protection argument, again, of disparate treatment between people that own vehicles versus people that don't, again, because of negligent entrustment and the registration.
Counsel, will you address the point that Justice Bruner had made, that there are alternatives short of seizure of property such as this, interlock, obviously license suspension, but we all know how well that works, and you know, the other maneuvers, or I guess the conditions that can be imposed by the court on this this defendant and others similarly situated.
Yes, there are other alternatives, Your Honor, and I believe again that at least with the second offense, based upon opposing counsel's statement this morning, interlock was imposed. It is
But here's my question about that.
Okay.
How long was the interlock? How long is that? You know, part of the consequence. Is that up to the court?
I'm not able to. I don't know that without. I don't know. I believe so, and I believe also there's the plates that can be placed on the vehicle that again are special plates that indicate
Right.
Again. So
Counsel,
there are
why not
intermediate measures, but again,
why not
I
just
think.
put a boot on the car?
I'm sorry.
Why not just put a boot on the car so it can't move?
Right.
That's a possibility, but again, the legislature has determined that based upon 3 OVI convictions in 3 years, that there should be a forfeiture proceeding hearing, which is what occurred here. And separately, in regard to this particular defendant, there are 3 separate disorderly conduct convictions, 2 of which have an alcohol specification. It's a serious situation. I mean, I've never met this individual. I don't want to speak disparagingly, but the public has a strong interest in keeping people that are intoxicated off the road. And
Yeah, but wouldn't a boot do that?
I'm sorry.
Wouldn't a boot on the car do that?
It
Stop. Okay.
It
So
would.
why not do that?
Again, I can't answer that question. That is a possibility, and it's obviously not as drastic as the forfeiture. But again, this is the 3rd one, Your Honor, within the 10-year period, and based on the recidivism provision that the Ohio legislature has established, there is a forfeiture proceeding. And again, it sends a strong message. Yes, it's harsh. Yes, it's drastic. But again, so is the conduct that is created this situation.
Mr. Fisher, I think that your opposing counsel has only argued this as applied and not on its face. So does that make a difference here?
It makes a difference in terms of the burden, Your Honor. It's clear and convincing as applied.
I understand, but in terms of how this would affect what you do and how this would affect the impact of the statute.
Yes, Your Honor. I believe that what opposing counsel has done, it's a well-written brief, but he focuses on case law from jurisdictions outside of Ohio. There's much said about an Indiana case, and again, he's focused almost exclusively on the difference between the $2,750 fine versus the value of the vehicle. And I would like to add that the value of the vehicle is not clearly established in the record. And if you look at the court order in number 4, the vehicle's value shall be determined by reference to the publication of National Auto Association. There's no real evidence. I'm sorry.
Could we get back though to this constitutional issue? Because if it's a case of first impression, then yeah, he's probably going to argue cases from outside the jurisdiction. So if it's a case of first impression, besides these factual issues, what is the case law that you think should best be used to apply in interpreting this new 10-year statute and how it affects Ohioans based on forfeiture?
I believe it's the case that the trial court used, State versus Herald. And I understand that it's not a horribly recent case, but I think part of the problem with the appeal is that the defendant appellant has no proposition of law with the assertion that the court's decision, the trial court's decision, is against the manifest weight of the evidence. Instead, he's made a declaration determination to challenge the constitutionality on its face, which is a different argument, I believe, and a different burden of proof.
I thought we agreed that it's challenging as applied.
It is as applied, but again, I still think that you're not challenging the court's decision and the criteria that he used. And I think that was brought up by the appellate court as well, that it's muddled, and again, respectfully muddled, in that the underlying decision, which typically would be challenged based upon manifest weight of the evidence, abuse of discretion, is not before this court this morning, which might allow you to examine the criteria, and maybe is the reason why the court, as a matter of great public interest, allowed this case and granted the motion in support of a memorandum in support of jurisdiction. But that wasn't raised here.
So, counsel, are we not to take in the value of the vehicle and relationship to alternatives and other factors here? We're just clearly looking at the words of the Constitution. Is that what you're saying?
I think we're looking at on the Constitution. The value of the vehicle is certainly an issue, and it's briefed extensively at $31,000. But I would submit again, there is no real finding in the record below as to the value. The defendant appellant paid $5,000 for the vehicle. He claims he put $8,000 of improvements in, but there is no evidence other than his testimony to support that. He claims it's worth $31,000. That's his testimony, but no other evidence to support the $31,000 value he claims.
Counsel, if we're looking at the Constitution, what we're looking at in Ohio Constitution, nor excessive fines imposed. So we do have to take into consideration what's excessive, okay, in relationship to, this individual. When we look at excessive, do we take into consideration the value of the vehicle? Do we take into consideration the effect this has on his ability to make a living and to, do other things that are required of an individual living in society with a vehicle and now without a vehicle? Are these all things that we balance in order to figure out whether it's excessive?
Yes, including the culpability of the defendant, the gravity of the offense. Those are all factors, Your Honor,
all right,
to be equally considered.
All right, so there are
law
factors.
as it presently exists. I'm sorry.
What about the defendant's income?
He wasn't working at the time of his arrest. He wasn't working several months later when the
I mean,
hearing occurred.
One of the arguments is that the trial court erred by not taking into account his own personal circumstances, the impact it would have on him. Should that something be considered in the analysis?
It's part of the analysis, Your Honor, but I don't believe it was properly raised on the proposition of law, either one or two. The trial court's decision, and whether it was supported or not supported by the evidence, is not per se before this court. It wasn't raised.
But when we're looking at what the definition of excessive is, I thought you just said we can take into consideration those sort of things.
Yes.
Okay.
Yes, that's true. But the issue as to whether or not the decision of the trial court should be reversed is
We're
not per se
yeah.
before the court. Right. That's all I'm saying, Your Honor.
I
Yes.
understand that, and,
Yes.
and we don't even have to go there. I don't know that you get an argument to that. I'm trying to figure out what we take into consideration, trying to determine what excessive is.
I think it's the factors under the current Ohio law. It's the factors, the 7 factors that the trial court took in consideration, State v. Herald. That's the
Okay,
case that the trial court relied on. That's where the criteria originate from. And it is an Ohio Appellate 9th District decision that was relied upon by the trial court. And that's what I believe is the benchmark that the trial court used.
Thank you.
That's
Thank
before
you.
That's before the Kish case, correct?
Your Honor, 1996 is State v. Herald. It may be before Kish. I don't have the date on Kish in front of me. I apologize.
All right, thank you.
All right, counsel, thank you. Counsel, you've used your time. You may take a minute. You'll have to unmute yourself.
Thank you, Your Honors. I just want to clarify for a second. The proposition of law number 1 is an as-applied challenge, which means that we take the facts as the trial court found them and then apply those to the constitutional questions. Proposition of law number 2
Was there evidence about the, did the court
facial
find,
challenge.
excuse me, did the court find the value of the car to be $31,000? Was there?
It did. We presented testimony from Mr. O'Malley, and I believe there were some exhibits also submitted to the trial court, NADA values of the car, and also the state did not have an objection to the $31,000 valuation. So we just look at the transcript from the trial court. So that's not at issue. The value of what the trial court found is not at issue here. We're taking that as it was found, and then we're just applying that $31,000 value to our 8th Amendment analysis.
Is the stay still in effect on forfeiture?
I'm sorry, is what still in effect?
Is the stay still in effect on forfeiture?
The stay is still in effect. The vehicle is in the possession of the Ohio Highway Patrol pending the outcome of this case.
Thank
So
you.
if the court rules in our favor, he would get the vehicle back.
Thank you.
Thank you, Your
Thank
Honor.
you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. All right, our second case this morning is 2020-866, the state of Ohio versus Kelly A. Foreman for the appellant. First, we have Mr. Jaquith arguing.
Thank you, Chief Justice O'Connor, and may it please the court. As the court is aware, Mr. Carey and I will be dividing argument time this morning as evenly as possible. I'd like to reserve 3 minutes for rebuttal. This case hinges on how possess is defined for the purposes of the felony drug possession statute. If one takes a common sense approach urged by the dissent and followed by the 4th District Court of Appeals in City of Logan versus Cox, then the state would have had to prove that Ms. Foreman had a certain quantity of drugs in her possession or under her control in Seneca County. If, on the other hand, one takes the approach of the majority below and the court in State versus Shrimplin, then it suffices for purposes of possession and thus venue that Ms. Foreman tested positive for drugs in Tiffin in late March 2018. To use the phrasing used by the Shrimplin court, which has been challenged by Ms. Foreman at every stage of the case, whether the cocaine was in appellant's pocket or in his urine is of no effect. But Ms. Foreman, however, respectfully submits that the Shrimplin approach is fundamentally flawed, and the holding of the 4th District in Cox is correct and should be applied here. In Cox, a minor was given a breathalyzer test which showed the presence of alcohol in Mr. Cox's body. Fourth District Court of Appeals, after discussing several cases from other states, which found that assimilated drugs could not serve as a proper basis for a drug possession conviction, determined that the breathalyzer evidence could not support a minor in possession of alcohol conviction against Mr. Cox because the prosecution was unable to establish where and when Mr. Cox possessed the alcohol that he had previously consumed. The key language relied on by the Cox court, drawn from prior decisions in other jurisdictions, is as follows. The drug has been assimilated into the body. The ability to control the drug is beyond human capabilities. Here, similarly, the only evidence is that Ms. Foreman tested positive for drugs. There's absolutely no evidence about the where and when of Ms. Foreman's possession of a usable form of cocaine. Thus, the state did not and cannot establish a venue in Seneca County. If instead of Cox, this court may be inclined to follow the lead of the majority below, or the Shrimplin opinion, the rule of lenity, as codified at Ohio Revised Code section 2901.04, creates an insurmountable hurdle for the state. Assuming arguendo, the General Assembly may have meant for assimilated drugs to serve as the sole basis for a possession conviction, but it is also reasonable to conclude, as the dissent did below, as we submit is much more likely, the General Assembly meant to criminalize only the possession of drugs in a usable form, as an ordinary person would read the statute, then lenity requires that the more defense favorable interpretation prevail. This results in the conclusion that Ms. Foreman stands unlawfully convicted of drug possession because the state failed to show when and where Ms. Foreman possessed cocaine. The dissent did a magnificent job of laying out why Ms. Foreman's position should prevail here. I think added to the dissent's view would be the rule of lenity analysis laid out in our briefing. Unless the court has questions.
Counsel, I understand your argument about where, but technically we know when she had drugs. She said she took them while she was pregnant, right?
In a range, yes.
Okay.
Yeah, she made some statements.
So we know when. I was just responding or asking to make sure I understood the facts, because you said we don't know when.
Yes, I suppose that implicitly I was contrasting it with a case like State McGowan, which is in the briefing, where there was a 2 to 4 hour window of prior consumption. And the testing, along with expert testimony, established that 2 to 4 hour window. Here we're looking at her last admitted usage was roughly a week to 10 days before the testing.
Right. Thank you.
If the court doesn't have any questions, I'm prepared to yield my time to Mr. Carey to discuss constitutional issues.
All right, Mr. Carey.
Thank you, Chief Justice O'Connor, and may it please the court, my name is David Carey, representing the amicus party, the ACLU of Ohio. The state has offered 2 venue theories over the course of this case. One was that Kelly Foreman was in Seneca County when she held cocaine in her hand or when she used it, or possessed it in the traditional sense. But as Mr. Jakewith explained, the state failed to gather or present evidence to support that conclusion beyond a reasonable doubt. So they've now presented another theory. And it's the second one that creates a major constitutional problem. No one disputes that the presence of cocaine or metabolites absorbed into bodily substances can constitute evidence of prior possession somewhere at some time. But the state is now arguing that it constitutes possession in and of itself. Even if the statute did support that interpretation, prosecution under that law would be unconstitutional under the 8th Amendment and under Article 1, Section 9 of the Ohio Constitution. Because under that theory, once a person takes a substance that is prohibited in Ohio, regardless of where and when they do that, they would be continuously re-offending simply by being here. And for as long as medical and forensic technology could detect metabolites, that person would be physically incapable of not offending, not because of a compulsion to act, as with addiction, but because no act would be needed at all. And that is exactly the kind of status offense that the US Supreme found unconstitutional in Robinson and then again in the plurality opinion in Powell. And for good reason. If possession could be by assimilation, a person could be convicted without ever holding or using a substance in a place where it is unlawful to do so. Their status would effectively render them radioactive, continuously reoffending wherever they went. And this would be for an extended period of time because cocaine metabolites are detectable in urine for several days. In meconium, as we saw in this particular case in the record below, it can be detectable for months after the actual use. And in hair, it can be effectively detected indefinitely, as long as the hair is still present to be tested.
You're essentially saying that this second venue theory is a status violation.
Precisely, Justice Brenner.
And I think there's already evidence, or excuse me, a case law out there that we don't criminalize drug addiction.
Yes, that is correct. And that is the Robinson v. California case. And this court has observed that in Akron v. Rowland, that their case, I believe the court said the case law is legion, that status cannot be criminalized.
So it seemed like it's the Prosecuting Attorneys Association's theory that because she had the baby in Seneca County and gave birth, that somehow there was a transmission that occurred at the point of birth, but it seems like if they found it in the umbilical cord tissue, I don't think that was a one-off kind of thing. Do you?
Well, again, we don't dispute that the presence of the substance in the body can indicate prior use. But in order to satisfy that requirement of venue, what they've essentially argued here is that the presence in the body at that moment was possession. And that's the part that creates the status distinction. By having a substance in your body, by having the status of being someone who once did that, who once used it, regardless of where and when, that status is what is being criminalized under that theory.
I understand. It just seemed like the Prosecuting Attorneys Association's argument was somehow that the birth was some kind of a marker where there was somehow the possession or the passage. And I'm just thinking about the fact that it was in the umbilical cord. That meant that it had to have been there before the child was born.
Right. It would have been before the child was born. I don't think that's been disputed here. And what's the offense here is one of possession. So the theory, as I understand it, is far simpler than that. It's simply that because she had it in her body at that moment, she possessed it. And because it was found in the umbilical cord, that is evidence that she possessed it while the umbilical cord was in her body. And that is the status that we are saying is being criminalized here and that is unconstitutional. And the plurality in the Powell v. Texas case elaborates on this a bit, talking about the act status distinction. And in that case, they were talking about public drunkenness. Again, punishing the status of being drunk, of being intoxicated, was impermissible on its own, without the act of choosing to be in public. Even if that act in and of itself would have been innocuous, the combination of the status and the act could be punished, but the status in and of itself could not. And that's true even if the drunkenness was voluntary. And that's also consistent with Robinson, which dealt with the crime of being addicted to narcotics, which the court found unconstitutional. While certainly no one chooses to be addicted, the addiction may well be the ultimate result of a voluntary act. But criminalizing that status is unconstitutional either way. So I'll pause there for a moment if the court has any further questions about the Eighth Amendment matter before I proceed to discussing privilege. All right, another impact from the state's novel theory of possession here would be to effectively turn almost anyone who gathers or possibly even encounters a positive drug screening into a mandatory reporter. Currently, it is the law that many doctors can be required to testify if called upon to do so about the results of a screening, but they would not be required to affirmatively report. And as we explained in our briefing, this ruling could change that. Contrary to the state's arguments that they've made in briefing, no one is suggesting that this court limit reporting requirements. Instead, we're saying that this court should not countenance the state's invention of a new doctrine that would have the effect of massively expanding those reporting requirements, effectively turning a doctor or anyone else who encountered a positive screen into a mandatory reporter. That would upset the balance that this court has observed in Antill and in Smorgala and in other cases.
So, I mean, if a doctor observes that a baby is born addicted to drugs, do you think that the doctor should not be able to report that?
No, Your Honor. If there are currently mandatory reporting requirements, then we are not suggesting those be disturbed. What we're saying is that the impact of this case, as explained in our briefing, the impact of the state's theory would be to turn any doctor, regardless of context, who encountered a screening result of that nature into a mandatory reporter. So it would be expanding the mandatory reporting. And it would upset that public interest balance that this court has observed several times between preserving patient confidentiality and preventing a chilling effect on seeking treatment versus the state's interest in investigating crimes.
Counsel, if the doctor was required to report, for the child's welfare, could he have reported her for this drugs in her system and child endangering been an appropriate response by the state?
Yes, Your Honor. We're not suggesting that that law needs to be changed. In fact, we're simply arguing that it should not be changed.
Well, okay, all right. She was charged with possession when the state could have just as easily charged her with child endangering.
If the elements of that offense were met, Your Honor, and I take no position on that.
Okay.
So one final point, and I want to reserve some time for Mr. Jake with rebuttal. Much of the state's brief here is given over to the idea that Ms. Foreman personally must be punished somehow. Now, it's worth noting this case is about criminal prosecution, and no one is suggesting that drug use is irrelevant to child custody determinations. But this case is actually more fundamental than that. The state does not have the power to punish someone under criminal law unless it can prove they committed an act that was illegal at the place and time that it was done, and that place was within the power of the sentencing court. The state here is effectively asking to lift that limitation on its own power, to allow prosecutors and courts to reach outside their territory and perhaps even extend one state's laws into another state by criminalizing the ongoing status of being a person who once did something as its own continuing offense. Robinson prevents that expansion of power, so I urge this court to reverse. Thank you.
Thank you. All right, first we're going to hear from, is it Ms. Baresh?
Ms. Barish. Chief Justice O'Connor, Justices, may it please the court. My name is Rebecca Barish, and I am Assistant County Prosecutor in Seneca County, and I represent the state of Ohio in this matter. At this time, I'd like to reserve 5 minutes for amicus. The state of Ohio would assert that through the facts and circumstances of Ms. Foreman's case, that possession was properly established within Seneca County, Ohio, and as was venue. Your Honors, on March 15th, 2018, JB entered this world in Tiffin Mercy Hospital in Seneca County to Ms. Foreman. The delivery was normal. However, shortly after his birth, many tests were done on him, including an APGAR test, which quantifies infants' health and measures that against infant mortality. His scores began to increase, and Tiffin Mercy is prepared to deal with children that have a level of 8 or lower. JB had a score of 12. That, along with other tests, specifically of his urine, his stool, and umbilical cord, tested positive for cocaine. That, along with the APGAR test, indicated to doctors that he was suffering from neonatal abstinence syndrome. Because of that, he was life-flighted to St. Vincent's Hospital, who was more prepared to deal with that severe condition.
Counsel, based on all those facts, wouldn't it have been better to charge the mother with child endangering?
Your Honor, I believe that the facts and circumstances go more towards, obviously, the indication of possession of cocaine. There are certain restrictions with child endangering that we are unable to, obviously, we do not want a chilling effect, but we want to make sure that the proper charge is, in fact, charged and prosecuted, Your Honor. Again,
Okay,
Dr.
what was wrong with child endangering? Why was that improper? Why would child endangering have been improper? It seems like that's exactly what she did.
Your Honors, we would assert that I believe other case law had supported the possession of drugs, specifically cocaine, to be better suited for this. And that the elements were proper through this course.
Well, counsel, you mentioned, I think just briefly in response to Justice Donnelly, you said something about a chilling effect. Explain that.
Yes, Your Honor. Obviously, we do not want mothers who are pregnant to not seek medical assistance or help or to give birth at home. We want them to obviously go to the hospital to be able to give birth properly.
So you're saying, counsel, are you saying that if child endangering was the charge that was she was indicted upon, it would be more of a chilling effect than possession of a controlled substance, here cocaine? One's more chilling than the other?
Your Honors, I would assert that child endangering, after having so many convictions, would be an increase in a felony. It goes from misdemeanor to felony, and obviously, I do not know the exact amount with what occurs with John Family Services. However, our policy through our office is to prosecute this as a possession of drugs rather than child endangering. Your Honors,
So how much, I guess your theory is she possessed it because she had the drug in her system. So under the statute, is there any minimum amount that someone needs to have to be guilty of possession if the drugs in their system?
Your Honor, I believe that cocaine is, the definition of it includes metabolites. And as drug tests are conducted, metabolites, when they are still found, are still constituted as the actual drug of cocaine.
How long do metabolites last in someone's system?
I believe it could be up, I do not know the exact, I do not want to mislead the court. I do not know the exact timetable. I know it can be rather lengthy because if it's a metabolite. I would say probably up to a week to 2 weeks. But again, Your Honor.
So if someone travels to a country with liberal drug laws and uses an illegal drug and they come back to the United States, they can be charged with possession?
Your Honor, I would assert that there was an act, and further in the United States, it is still illegal to be in possession of that drug.
So it's illegal if you went to Amsterdam, for example, and used cocaine, came back the next day, and there were traces of it in your blood or hair. That would be illegal in Ohio?
If for some reason that you were submitted to that testing, then yes. But again, I would assert that there has to be something that would flag you, or not flag you, but something that would put you, say if you're driving a car and you were under the influence, then yes, that would.
And Counselor, essentially you mentioned that because Chapter 2925 makes no mention of drug metabolites. So it's unclear whether we can even consider that it qualifies as a drug offense. And to your point, Chapter 4511 does talk about controlled substances and metabolites. So don't we have to follow the maxim where, the legislature obviously intended metabolites to be considered a drug or be considered in the offense in one statute, and because the legislature does not have it in another, that was the intent?
Your Honor, I would still assert that the definition of cocaine is still controlling, that when we look to the possession of cocaine, cocaine is still defined as a metabolite, that even though it is specifically delineated in 45, the definition of cocaine still stands even in 2925. Even though it's not specifically delineated, I think it is still proper to support that its metabolite form is still cocaine.
What about the definition of possession? Doesn't that have an element of control to it?
It does, Your Honor. However, supporting case laws such as Moyer would also include that possession can be asserted through constructive possession, as well as looking to the facts and circumstances that involves not just what is mentioned in that definition. It is further, it's not just a very minimal view that is being presented by the appellant. However, it is still able to be understood throughout case law to expand to more. And we need to look at the facts and circumstances, as was it here through the appellant, who admitted that she used 6 to 12 times throughout her pregnancy every 2 to 3 weeks, and that she had done so a week and a half before giving birth. That is support.
But if investigators could get her to admit that, why wouldn't they ask her where she did it?
Your Honor, it was Job and Family Services who had spoken to her. She did not make contact with the detective in this case, who had tried repeatedly to make contact with her. So Job and Family Services had asked her. However, they're not law enforcement necessarily to know to ask that question, and that was not asked. However, I do. Yes.
I want to go back a little bit to Justice DeWine's question. What facts and evidence show control, however minimal, while in Seneca County? Could you delineate those facts in the record?
Your Honor, we would still assert that even if it is in the body, it is still in possession. Shrimpland does not go against it, whether it's in the pocket or in the urine, or we would assert here the umbilical cord, that it is still being possessed and controlled in her body. Obviously.
Well, but Counselor, I mean, the majority of cases across the country finds, things in your system is the antithesis of control. That, because as you say, possession does convey a sense of control over something. But when it's in your digestive system, you have no more control. Once a drug is ingested, the power of a person to control it, possess it, or use it is at an end. It doesn't exist. You can't give it to someone else. You can't flush it. You don't. So, and isn't that what the case law really across the country holds?
Your Honors, I would still assert that even though it is within the body, it is still present and still in the control state. Obviously, Ms. Foreman chose not to present Job and Family Services with a drug test when asked. She said she wanted to wait until she would be clean. Your Honors, even though that you may not be able to pull it out of your body, it is still able to be in the body, and through that, it is through the umbilical cord, it is still present.
Counsel, if
could she be charged?
Oh, I'm sorry, go ahead.
Could she be charged with possession in every county? If she were traveling throughout Ohio, could she be charged with possession in every county?
Your Honor, we would assert it is found to be in Seneca County because that is where it was tested. That was where it was made available because that is where she gave birth. We're not trying to say that she should be found guilty everywhere, but if not here, where? Because obviously,
no, I'm not saying guilty. I'm saying charged. Could she be charged if she went from several counties?
If she gave birth in that county, then yes, possibly. Looking at the facts and circumstances.
Okay, so you're only saying if there's some evidence because she gave birth, there was some physical evidence that she had cocaine metabolites in her system at that particular time.
Yes.
Okay.
Counsel, you said that the control, somehow you mentioned, or maybe Justice Stewart did, about ability to, use it, pass it on, whatever. Here, she used it and she passed it on to her unborn child. Are you saying, to me, that is the definition of child endangering. So I keep going back to the inappropriateness of, the charge compared to what we were actually presented with here, which is child endangering, with a child that was born addicted, obviously, which suggests more than just a casual use of drugs, contrary to her representations. I know you're saying this is your office's policy, but like Justice DeWine, I don't understand I just don't understand why this is the path that that we're on in this case.
Your Honor, I would, at this point, I would still assert that the facts and circumstances in this case went more towards that she possessed cocaine within Seneca County. I would defer to my colleague at this point, who may be able to answer that question more readily than I.
All right, Mr. Carey.
Mr. Arrow.
Thank you, Your Honor. May it please the court.
I'm sorry, Mr. Harold.
That's fine. To clarify a couple of points, the question of why not child endangering, the state would endorse this court recognizing what occurred here as a whole host of crimes, from felonious assault to child endangering to corrupting another with drugs, all of which have a much higher felony and punishment level, especially the ability to imprison a defendant than drug possession. I think in that context, treatment was the key issue here as opposed to punishment. As it relates to why not child endangering, I would direct the court's attention to State versus Gray, a case from the early 90s from this court, where child endangering in a criminal context was disfavored. About in 2000, Inroy Baby Boy Blackshear limited that holding and argued that that could be a reason for a permanent custody determination. If this court would like to revisit State versus Gray and allow for a child endangering prosecution in that regard, the state would not in any way oppose that.
I don't understand what you're saying. Child endangerment in a criminal context is disfavored. Child endangerment is a criminal statute. So what other context would it be used in?
Well, in the concept of a child being endangered as it relates to abuse, dependency, and neglect was found to be an appropriate reason for a permanent custody determination in Inroy Baby Blackshear. In State versus Gray, this court found that child endangering could not lie in a criminal prosecution under facts somewhat similar to this case. However, the state would not oppose that being revisited because child endangering in this context seems to be an incredibly appropriate charge, as well as possession.
Well, I mean, if the elements of the crime are met, there's no reason the state can't charge him with that.
Correct, with the exception that State versus Gray, as a matter of precedent from this court, says that that charge is not available to the state in charging a mother with having a drug-addicted child. And again, if the state would embrace the court departing from that, I think child endangering in that context would be exceptionally appropriate in this regard. To a certain extent, the state was limited in what they could charge to get Ms. Foreman into treatment.
Well, counsel, let me just understand. You say State v. Gray precludes the state from charging a drug-addicted mother who gives birth to a drug-addicted child from being charged with child endangering.
Yes, Your Honor.
Okay.
It's 62 Ohio State 3rd, 514. Very early on in the decision, the defendant in that case was a Tammy Gray. But again, the state would welcome this court revisiting State versus Gray. That would be, I think, a very just result in this regard. As it relates to status, there's a great difference between the defendant in Powell and the defendant in Robinson and the defendant here. Her status of being a drug addict is not being prosecuted here. Drinking alcohol in Powell is legal. And this is not an issue where we have old track marks on somebody's arm. In the context of possession, there wouldn't be any issue if Ms. Foreman bought a bag of cocaine to the hospital. Here, the cocaine was found in her blood and in her child's bodily fluids. In addition to that, the question of how long metabolite stays in the blood, the state would draw this court's attention to State versus Scott, a Cuyahoga County case, where we get a number, which is 72 hours. So in this regard, we know that Ms. Foreman used cocaine within 72 hours of birth. And in that context, you know, we know that she has exclusive control of her child. In
Mr. Harold, under the state's theory or argument, could after the baby was born, if the father came to the hospital and picked up the baby and went home and the metabolites were still in the baby's body, isn't he possessing drugs? Then he could be prosecuted, right?
I don't believe that's a fair way of looking at that. Truly, when we're looking at drug possession, there is a great difference between if I pick up a drug addicted friend at the hospital and drive them home, I'm not being charged with possession of drugs because the exclusive control argument really doesn't sound. There's a great difference between having a child that you are directly passing drugs to. The cocaine that this child had, it directly comes from the mother. There's no other way for that child to get cocaine in its system. So, you know, I would argue that the context of the father bringing the child home, you know, because that child has drugs in its system does not constitute possession. And
Mr.
I would
Mr. Harold,
yes, ma'am.
The thing is, the fact, look, there's a piece of the umbilical cord still attached to the baby when the baby's born. So in that tissue, they found drugs. How do we say that at the moment of birth was the passage of the drugs from the mother to the baby's system? Well, we really don't say that because we know the baby was born drug addicted because the APGAR score went up the longer the baby wasn't getting continuous supply of cocaine from the mother's system. So I still don't understand how that point of birth creates the possession on the part of the mother. I understand your co-counsel talked about the metabolites, but can you help me?
Certainly. Yes, Your Honor. The idea that the mother's blood is still in the umbilical cord, physiologically speaking, that's a fact. The umbilical cord is truly the sharing of both the child and the mother. So the idea that the blood in the umbilical cord is much like taking blood from Ms. Foreman's arm. Taking blood from the umbilical cord has the exact same effect as it relates to control over that. So that's the idea. I think the concept of at birth relates to discovery. Had Ms. Foreman been driving in an impaired state or had an involuntary manslaughter cause of death after a traffic accident, and it was found that she was driving in an impaired state, the blood taken at the time that one would presume that she was in the hospital or with law enforcement would constitute the marker of time of when it was discovered. Discovery could not have...
You couldn't charge that mother for possession of drugs, though. If you didn't find drugs in the car, you couldn't charge her with possession if you just found it in her system, could you?
Yes, Your Honor, you can. And that's the Shrimplin and Napper and McGowan deal with the fact where in most of those cases, an individual has committed another crime while high on cocaine. All of these are cocaine cases. And the individual's blood is tested because cocaine is found in its metabolite form. And I believe when you look at the definition of both cocaine as well as how broad possession is under 292511, it allows for cocaine to be in its metabolite form because it's allowed to be in any container, whatever that may be, whether it's the bloodstream or if it's being mixed with something else, that still constitutes cocaine. It just so happens that
the Shrimplin in those line of cases are unreported and they're unsupported by any other law.
Well, Your Honor, if you're looking for a reported case in that regard, I would encourage you to look at State versus Lowe from the early 90s out of the 4th District, where you have a similar situation. And the 4th District said, well, we're uncomfortable with just having the possession of cocaine metabolite in that individual's bodily fluids. we would, if there was something else to substantiate it, if the person was around drug materials, if the person confessed, which is what we have here. She's admitted on a number of different occasions to using cocaine while pregnant. And by State versus Scott, we know that even though she didn't, that it was in her system within 72 hours of her use. So she didn't tell the Job and Family Services that she used it in the hours or days before the birth of her child. She chose to keep that out, but it doesn't change the fact that it occurred. And I think that State versus Scott endorses that. And I think when we look
you're
at
going to take State versus Scott and say it had to be within 72 hours, and the fact that, and she admitted it, that she used it. So you're going to impute the 72 hours, the State versus Scott. And then how do you get to the fact that it was that when she used it, it was in Seneca County? How do you get there?
Again, it's the possession does not require use. And I think that that's one of the big differentiations that needs to be made here. Again, if this was cocaine in a baggie in her purse, we would say, oh, absolutely, it's possessed because it's within her dominion and control.
Sure, but it's the flip. She didn't possess it and she used it. How do we get venue from that?
Because its presence concerns its control and its possession. If it's present, and specifically cocaine metabolite, which is what all of these cases concern, its presence in her body at a time that it is discovered constitutes possession. On the same token, there was a question that said, well, if she drove through a number of states while possessing the drug, could she be prosecuted there? And the answer is yes. And I would encourage you to look at it in the context of an RSP case. Someone received stolen television sets in Toledo, and they're going to fence them in Franklin County. Well, as you're driving to Columbus, you could be prosecuted if it was discovered in Wood County or Hancock County. If that person happened to be discovered in Marion County is the most likely place for the prosecution to occur, but it's not the only case. But discovery is what drives citus for many prosecutions, which is why it drove it here. So the possession was discovered in Seneca County.
Counsel, so can every probationer who's on probation for a felony that comes in and tests positive for cocaine now be charged by the state with possession?
The question of there's a can and a will question there. Can the person be charged if they have a dirty screen for cocaine specifically in a probation office? Yes, that person could be charged with possession of cocaine. That's accurate, and I think we look at the attendant circumstances around that possession as well.
Has that ever occurred? Has that ever occurred to your knowledge?
I do not know of a case, Your Honor. I'd be more than willing to look, but at this point, I know of no case where those were the attendant facts. The vast majority of the cases that deal with possession of cocaine metabolite occur where that discovery was made in a case surrounding, for lack of a better term, other issues. And for that matter, I would like to differentiate the minor in possession cases. Alcohol, even the only thing that makes the possession of those individuals of having alcohol in their system illegal is their age. And that is a status issue because the individual in that context could not control their age, and the legal possession of that substance, the possession of cocaine, is never legal. And I think that that's a distinction that this court should note.
Thank you. Thank you.
Thank you.
Mr. Jaquith, are you going to argue at this point?
He's muted.
Also, we don't have your mic on. So maybe it's on and we can't hear it. Okay. Mr. Carey, would you like to step in?
Very briefly. Counsel mentioned the Scott case, which had a passing mention of metabolites being detectable for 72 hours. I would simply mention that that case was from the early 1990s. Technology has evolved since then. And also the Scott case does not stand for any legal limiting principle. It does not say that metabolites are only useful under the state's theory here if they're detected within 72 hours. It's simply descriptive under the science of the time, saying that it was detectable for 72 hours. And further, as for the discussion, if I understood counsel correctly, as to charging with child endangerment versus possession, if I understood their position correctly, it's that the offense of possession was charged because it was essentially a less harsh penalty. Of course, the elements must still be met.
Counselor, I think what they said, and to be fair, I went back and read the case that Mr. Harold cited, was there's precedent from this court saying you can't charge with child endangerment for endangering a child who's not yet been born. So that's why they had to charge it this way.
Fair enough. That if they couldn't charge for child endangerment, then they couldn't charge for child endangerment. But that, of course, is not a reason to charge for an offense that where the elements cannot be met or where the offense would be unconstitutional as applied here. And with that, I have nothing further.
I have one follow-up question. State v. Gray, as Justice DeWine was saying, I mean, why wouldn't State v. Gray operate in this situation to prevent prosecution for possession? I suppose maybe because of the question of metabolites, but as Justice Stewart pointed out, that's not really in the statute like it is in 4511. So wouldn't State v. Gray actually help in preventing prosecution in this situation?
I don't know that State v. Gray speaks to the Eighth Amendment issue, but if State v. Gray prevents prosecution for child endangerment, then obviously she couldn't be charged under that. As to possession, our position is simply that the elements have not been met beyond a reasonable doubt, or rather that venue has not been met beyond a reasonable doubt, and that the prosecution would be unconstitutional.
Thank you.
Thank you. Thank you, folks. We'll take the matter under advisement. You'll be notified of our decision. Marshall, we call a 10-minute recess.
The court will now recess for 10 minutes.
our third case this morning, 2020-1037, Julia M. Ostanek versus Gregory F. Ostanek. For the appellant, Mr. Cuban.
Thank you, Your Honor. I'd like to reserve 4 minutes of my argument at the end. This case is about the principle of finality of judgments. This court recently reviewed an 11th District Court case on qualified domestic relations orders in Walsh. And in reversing that decision, this court stated that the lead opinion was wrong to disregard the Civil Rule 60B, our 60 Rule 60B jurisprudence. Faced with this mandate, from the 11th District Court attempted to bypass this admonishment by categorizing a valid COAP or a QDRO order as void. Now, what that allowed the court to do is disregard the mandates of Civil Rule 60B, in that if one is challenging a valid court order, that they must do so within a 1-year period of time. That case could have been decided simply by stating that the movement waited 2 years and was therefore out of rule. This court could have done the same thing, but what they attempted to do was reach and say that the court order is void. Now, at best, this court order is voidable and not void. And a list of cases have gone through that, and it appears that the 11th District Court is the only one who keeps on holding on to this concept that if there is a mistake in a qualified domestic relations order, that simply makes the order void as opposed to voidable. Buttressing our argument on this is that when the court examined the QDRO in this case, there were 2 aspects to it. One was the aspect regarding the coverture versus the frozen, and the second part dealt with the survivorship. Now, I find it curious that this court upheld the first part whereby the coverture method was used, and the court simply said that that was proper. But then on the other hand said that when it came to the survivorship benefit, that the court made an error and therefore it rendered it voidable. It would either, in my opinion, it would either have to go one way or the other as to both aspects. You can't have one aspect being correct and one aspect being incorrect and still upholding a part of the order. I think the best argument has been laid out recently by the 8th District Court in the case of Fitzgerald. And at paragraph 14, it basically sums up the reasoning. It said, we find that the interest of justice is served and procedural difficulties addressed by declaring that the issue of the propriety of a QDRO is voidable for error and therefore subject to appeal. Subject matter jurisdiction is not implicated where a trial court has reserved jurisdiction to modify the terms of a division of property, of marital property. Where simple error does not initially exist, but a planned administrator subsequently rejects a QDRO, the proper vehicle to address the matter is through a 60B motion. Central to that is when one is faced with an order to which they object, that they cannot sit on those facts forever and then seek relief from the court. These are unusual circumstances in this particular case where the parties were divorced in 2001. They waited until 2013 in order to draft and have the qualified domestic relations order filed with the court. But most central to this case is that after 2013, when Mr. Ostanek retired and he found that amounts were being taken out of his paycheck, he waited an additional 5 years in order to seek relief from the court. 5 years is clearly out of rule. If he had any argument at all with this matter, he should have done so within the 1 year period prescribed by Rule 60B. He failed to do so. So we maintain that there are several problems with the Court of Appeals case. The most central one being that the QDRO is not void, it's voidable. Most courts are of that opinion. And simply put, if he did have a problem with the order, even though in our mind it is correct.
Could he have filed a direct appeal from the QDRO order?
Can he or did he?
Could he have? Is that something that's appealable?
Yes, he could. And that goes back to what I stated with what was held in Fitzgerald. If you have a qualified domestic relations order and you see it come out and you feel that it's improper, you can file, you should file an appeal from that order at that time. If later on something comes up and that QDRO is rejected, then you can file a 60B. He did neither in this matter, and he didn't do anything for 5 years until he filed this 60B under the catch-all subsection 5.
What was section 1, 2? I mean, he filed it under 5. Any other reason? But
that's a curious aspect about this. When he filed the original motion, he filed it under subsection B, under subsection 5. And the reason that that he gave in his motion is that an incorrect amount is being taken out of my account. That was it. He simply said too much money is being taken out, as opposed to me receiving X number of dollars. I'm receiving.
Did anybody argue that that a mistake needs to be filed under, I don't know if it's B1, 2, or 3, but it's one of the first 3 sections, and that the timeline for that is only a year? Was that argued below?
Nothing was argued within a 1-year period of time.
Yeah, was argued that because it was I mean, I saw the discussion about whether the time was reasonable, but I know at least in some districts, there's case law that says that when you have an explicit section that applies, you can't use B5 with its unlimited time or reasonable time to get around the 1-year time limit. I'm wondering if that argument was raised below.
It was raised below, and I proffered an argument which in fact came out to be out correct. If the OMP, which is the government branch which is dispersing the monies, was making a miscalculation based on their reading, they could have corrected that without attacking the QDRO. And in fact, that's what happened in this case. Mr. Ostanek went to Representative David Joyce, asked him to look into this matter about the incorrect calculations, and that matter was resolved on its own through internal calculations with the government. There was no reason to attack this order based on an incorrect amount, which is what he originally tried to do. So his original complaint was taken care of by itself without having to go through all of this and opening it up to review by the 11th District Court.
As far as the 60B motion, the response that I'm seeing is that the service of the document in 2013 didn't reach him because it was sent to the former marital residence on Town Line Road that no one had lived at since 2001.
There was an argument, and I submit it's a red herring. There was an argument that was made. The responses, the trial court found that Mr. Ostanek should have taken some affirmative action on his own, which being to put a correct address with the court. But nonetheless, the facts and the circumstances of this case bore out that even if Mr. Ostanek would have received the papers from day one, he still wouldn't have done anything, because as shown by this case, when he retired in 2013 and he saw that too much money was being taken out of his check, he didn't do anything for another 5 years except complain to himself that too much money is being taken out. So the fact that,
but at the time of the divorce, I just want to go back to what Justice Bruner asked. At the time of the divorce, the active address that the court had was he was living with his parents. That address had never changed with the court. So why wasn't it sent to the only active address that the court knew?
The answer is there was a 12-year gap between the time that they got divorced and the time that I was contacted to start proceedings with the Qualified Domestic Relations Order. I no longer had that file. That file is 12 years old and in storage. And there was a bit of urgency with regard to getting it done because Mr. Ostanek was retiring.
But it's on file with the clerk. You didn't need to go to storage or anything else. You could go to the court and actually find that address that was still on record with the court.
The address that was on record with the court is the one that I sent it out to. At the top of the docket sheet, it has the parties and it has their addresses with their biographical information, and that's the address that I sent it to. I did not make up an address. I did not do anything. I sent it to the address that was on file with the clerks, and it was the official address as far as everyone was concerned, including the trial court was concerned.
Did you ask your client where he lives?
I took the address that was the official address off the record.
That wasn't why I asked you.
My,
Did you ask your client where he lived? Did you do anything to, it had been 12 years. Did you do anything to confirm that this would get to him?
I did ask my client. I did not get an official address from her at that point because my understanding is she had no communications with this individual in the intervening 12 years. If I had gotten another address, I would have provided it at. I would have made service. There would be no reason for me not to serve it at the address that Mr. Ostanek was, or an address that he gave me. I would have done that. There was no reason for me not to do that, Your Honor.
Except for the decree itself sets forth that the marital residence was to be immediately sold. In the clerk's record, he was living with his parents, but that's not where the QDRO went to. The decree itself said that that home was to be immediately sold. So
Correct.
12 years later, you're telling me that logically someone would believe that the house still had not been sold? You couldn't go to the auditor's record?
Your Honor, many things could have happened, and I could have done a lot of things. I sent it out to the official record that was on there. With regard to the house being sold, with regard to a house being sold that was in litigation 12 years ago, frankly, that was not in my memory. So simply put, there was some urgency in order to get it done at that time. Should have been done in the intervening years. I checked the docket, got the entry, gave it on the official record that was with the court, and we went through this with the trial court, and Judge Falkowski found that Mr. Ostanek could have done a number of things with regard to updating his address, and he didn't, and we simply sent it out to what was the official address on the court docket.
Okay, proceed.
Thank you. I see my time is winding down. So getting beyond the fact of this service, and I understand that that's an issue, but that has been litigated in the trial court and found that the address that it was sent to was proper. I feel the major issue in this case is whether we can deem errors in qualified domestic relations orders and make those orders be void if they contain an error. And simply put, if there's an error in an order, that should be attacked through a 60B motion as finding it being voidable. What the Court of Appeals should not do is on its own, simply deem an order to be void and therefore go around the constructs of Civil Rule 60B. So there were a number of ways that the court could have upheld the QDRO in this matter. They should have upheld it, and we're asking the court to reverse the Court of Appeals on this ground. Thank you, Your Honors.
Thank you. Mr. Cahill?
If it please the court, in this matter, there really are two major issues. The first issue is that the entry, the COAP was void, and was my client afforded procedural and substantive due process. As to the due process argument, we know what that means. If you're going to take something from me, let me be heard. Give me a chance to defend myself. My client was never afforded that. Now, the 11th District Court of Appeals on the very last page felt that argument was moot due to the fact that it ruled in his favor as to the COAP being void ab initio. But I do believe that the 11th District should have addressed that. And why? Because the final hearing on the divorce was April of 2001. The judgment entry of divorce was 6 months later, October of 2001. There's no doubt that in 2001, April, both parties lived at the Town Line Road home. And then immediately after the hearing, my client moved to his parents' home in Wickliffe. And how do we know this? Well, we know this from the judgment entry of divorce that was prepared by Mr. Kubin that listed my client's address in Wickliffe. And
I understand your complaint there. I guess what is harder to understand is that once he knew that there had been a mistake made, and they started taking money out of his, and there'd been a quadrennial, they were taking money out of his pension. Why did he wait another, it was 4 years or 5 years to file something?
Well, my client went to the Office of Personnel Management, OPM, on 3 different occasions and said, what's going on here? I don't understand why so much money is being taken out. What my client didn't understand, what was never given to him, either by appellant's counsel or the QDRO group that prepared the COAP or OPM, was this COAP order. He never knew that.
Counsel, was he represented by an attorney?
At the divorce, he was represented by another counsel.
Okay. And the aftermath of the divorce, you know, with the QDRO and the co-op, et cetera, is that a highly irregular proceedings after a hearing on the divorce?
Absolutely. To let 12 years go by before you file an effectuating document to divide a pension? Absolutely it is.
No. What I'm saying, how soon after the hearing on the divorce was the QDRO figured out, drafted, you know?
12 years.
Okay. So that's the time gap here that you're saying was, I guess, unreasonable?
I would say it was, yes. And also to suggest that the appellant did not know where my client lived is just absolutely unsupportable. They have children together, first of all. And in 2006, the record clearly shows that appellant visited appellee's residence in Washington, D.C. To suggest that she didn't know where he lived is just not supported by the evidence. And she never
under the initial decree, was it her obligation to prepare the QDRO, or was it unspecified, or was it your client's?
It basically said the parties would cooperate in doing so. Okay. And Mr. Kubin contacted QDRO group to do the COAP. And then it was sent to an address that neither party had lived. And if you look at the addresses on the COAP that was submitted to
neither party did anything for 12 years, even though they really.
I'm sorry, sir.
Neither party did anything for 12 years, even though they both really had some responsibility to do it.
That is true, sir. But when you look at the addresses on the COAP, it had appellant's Medina address, new address, yet it still had the old address that the parties had lived in and sold. When you draft a COAP, you send the final decree of divorce to QDRO group. On the decree of divorce is my client's Wickliffe address where his parents live. So I
assume for a second that we at least partially agree with the appellant and say, you know, since this decision came out, we have changed our case law on void versus voidness, and we think that this is voidable, not void. Does it need to go back to the trial court to see whether the delay was reasonable in this case under 60b-5?
Well, that's possible. And I'd like to answer that by looking at the historical context of when this divorce occurred, which was in 2001. And I think that's really where the confusion started, because in the judgment entry of divorce, the term QDRO is used. when in fact the term COAP should have been used. Why is that significant? Because under federal legislation, under ERISA, QDROs are used to divide up private pensions, but this is a public pension. QDROs do not apply. It should have been a COAP. And at the very same time, in 2001, 2002, the state legislature was dealing with the DOPO issue with state pensions. So I think there was a confusion on a part of the attorneys at that time in 2001 as to what was the proper mechanism to use to make sure this pension was divided. And remember, with private...
Mr. Catt, I think you're getting kind of far away from my question, which is, if we agree whether that this was voidable, not void, does it need to go back to the trial court to decide whether the delay was reasonable or not?
Well, I think that is one issue that the court could decide, especially if he did not get this, but they also need to decide to what extent my client should continue to bear a cost that was never in the judgment entry of divorce, but that was put into the COAP. Presently, he is responsible to pay $18,000 for the survivorship annuity between 2013 and 2018. And he's also responsible to pay one half of the ongoing survivorship annuity of $135 per month. That was never in the judgment entry of divorce, and but yet it's in the COAP. I think this is truly a void ab initio case as opposed to voidable. I mean, just because you have parties in a divorce and the court has personal jurisdiction and they have subject matter jurisdiction, when the terms in this COAP are so
well, but I understand that's your position, but our case law seems to be now pretty clearly the contrary. If the court has subject matter and personal jurisdiction, then it's voidable, not void. So, you know, I guess I'd like some help with the question I ask. Is assuming that we think it's voidable, what happens next?
Well, I think you would refer it back to the trial court. But I think that the issue here is not so much that as to was the delay reasonable. I think it was reasonable in the sense that my client never got it. That was never disputed at court. The appellant never even showed up for the trial on this. So my client's testimony that he never received this was unrebutted. And from the documents themselves, clearly demonstrate he never got it. So I think that issue has really been resolved, and we're going back to, so now how do we apportion these costs that were never addressed in the judgment entry of divorce and shouldn't have been in the COAP? Because if my client had gotten the COAP, this document, you know, the appellant's argument is, well, even if he had gotten it, he wouldn't have done anything. We can't make that jump. We can't say because he didn't get it, he wouldn't have done anything anyways.
Well, Mr. Cahill, is if he had gotten it, served with the documents, it wasn't until he actually retired that he realized the amounts were not what he expected, right? So, I mean, could he have even known of the disparity before he actually retired and all the numbers start falling into place? One, and two, if again, he has his employer, his retirement plan has corrected the error and compensated him for his loss, what's there to fix? What would fixing the judgment entry do or modifying it do?
Well, Justice Stewart, this pension was to be divided evenly between 1978 and 2001. Yet, when it was actually divided and checks went to each side, appellant was getting almost as much as the appellee. So he knew right then and there something was wrong.
Right, but that wasn't an error that wasn't a mistake that came about through anything in the judgment entry, was it? The judgment entry was correct. The divorce decree was correct.
Well, yes, but anything that he acquired in that fund from 2001 to 2013 was his separate property. And my point being is, clearly, when they started getting checks that were similar in 2013, there was a mistake. And that mistake was not, it was rectified because Office of Personnel Management at the request of Congressman Joyce recalculated and said, yes, there was a mistake. But they still, what they did not rectify was from 2013 to 2018, the survivorship annuity was still liable to be paid by my client. And going forward to this day,
But
my client still has to pay something that he never negotiated.
But does the judgment, does the divorce decree address that?
No, it does not.
So then again, how would getting, this was filled in by the co-op, right? The COAP.
Correct.
And that's not something that OPM could correct also?
At this point, no, it cannot correct it because it was a benefit that's already been given by the fact that it was in effect from 2013 to 2018. Because if my client had died in that time period, then appellant would still have received a portion of the pension.
But the
So,
survivorship.
Counsel, I'd like to go back to the proposition of law. And you answered a question from Justice DeWine. You mentioned subject matter jurisdiction. Do you contend that the trial court had or did not have subject matter jurisdiction?
I do believe they had subject matter jurisdiction to issue a COAP, but they had to at least follow the requirements of the judgment entry. They couldn't fill in the gap. It's like basically saying that they omitted or added a term. You know, back in 2001, this survivorship was never discussed. Therefore, it's akin to saying, I forgot my child's birthday, except the child was never born. So you can't omit or purposely not put in a term if it was never even discussed. And that's really the basis of due process.
But Mr. Cahill, so it was the QDRO COAP process that dipped into the annuity because it was never in the original decree, correct?
Correct. And so I do believe that the court should have, the 11th district should have also addressed that issue. But getting back to the COAP, the point I was attempting to make is the non-participant doesn't have any type of property interest or ownership interest in a federal pension. They can share, but only under private plans do they get an immediate type of property interest. And I think that was the confusing aspect all the way back in 2001 that wasn't properly addressed in this matter. And I would only finish by saying at no time was the trial court ambiguous, or did it issue ambiguous terms regarding the COAP. It never even addressed it. It never even discussed survivorship. It never even discussed who would pay for that. Only later was that inserted in, which is a major deviation from what the judgment entry of divorce in 2001 allowed.
Counsel, is that pretty standard that something as important as survivorship rights or is unaddressed at the time of the trial court?
Well, do I think the attorneys at that time should have addressed it? I do. I think as I sit here today, is that standard? Absolutely. It's very difficult for me to go back 20 years ago and figure out what was in the minds of the attorneys at that time. But I think clearly they made a mistake using the term QDRO when they should have used COAP. The term COAP had been in existence since 1978. And there was even additional effectuating language in 1992 under federal guidelines. So there were certainly mistakes made. There were mistakes made in drafting back in 2001. There were mistakes in service. And there was certainly a mistake in the amount that appellant was getting because the feds cut a check to my client in the amount of $58,000 gross. So there were many mistakes here that were made. And I think the Court of Appeals was just trying to say, look, there are too many mistakes here. This is void. Appellee never got a chance to challenge it, never got a chance to say, wait a minute, there are mistakes here. And that's really the basis of our jurisprudence. If you're going to make me pay something or take something away from me, I get a chance to speak. I get a chance to let you know what I believe is appropriate. That was never given here.
Thank you.
Thank you.
Thank you.
Thank you, Your Honors. Addressing Justice DeWine question of whether this needs to go back to the trial court. I don't believe it needs to go back to the trial court. If you look at the court's judgment entry back in October of 2019, the court found that basically Mr. Ostanik's strategy was to do nothing and wait for the QDRO preparation to come to him. They also found his testimony to be disingenuous about his reasons for trying to vacate the order. So having this remanded back to the trial court to find out if it was reasonable or not, I don't think needs to be done because it's been already done.
Counsel,
Yes.
Did I misunderstand that it was that he started the process for the co-op?
He did not. We started the process for the QDRO.
What about the co-op?
I'm using those. If I'm confusing, I'm sorry. I'm using those terms interchangeably. It was the wife who initiated the proceedings once she determined that it hadn't been done and that the husband was retiring. So, getting back to the question of whether it needs to go back to the trial court, I don't think so. But the bigger issue is, even if it was sent out in 2013 to him, as Justice Stewart indicated, nothing really happens until 2013, until later on when he retires and things come into effect. At that time, once he found out that there was a problem, he should have filed an appeal, or if it was too late within 30 days, filed a 60B. Nothing happened. There may have been some errors that started out on this with regard to naming the type and this and that. But the biggest error was that Mr. Ostanik didn't do anything for 5 years and waited until he obtained counsel, and counsel then filed a 60B motion, which was too late.
Well, was that really the biggest mistake that was made here? Is that he didn't file a 60B? Or was
Yes.
the biggest mistake here that counsel waited 12 years to actually apply for QDRO and Associates to do the co-op, and unilaterally having the conversation with QDRO Associates that a distribution for the survivorship was put in that is clearly not in the decree? Was that really the biggest mistake?
Let me answer that. There are two parts to that. Let me answer. With regard to waiting the 12 years, I don't think it was either counsel's responsibility. As a practical matter, what needs to be done is certain affirmative acts need to be taken after the divorce, certain payments need to be made, QDRO consultants need to be retained. There was a void. Neither party did anything and sat back until there was a retirement. At that time, when they contacted counsel stepped into play and did it. But more importantly, regarding the survivorship, and this decree was silent as to whether it's a coverture method or a frozen method, and it was silent as to survivorship. We went through that in the trial court. Both the magistrate and the trial judge found that these were part and parcel of the retirement that was supposed to be split 50-50. Mr. Cahill also had his expert witness, Brian Hogan, which is with QDRO Consultants, and he says that the traditional way of doing things is if there's silence as to the method of division, it goes to the coverture method. If there's silence as to the survivorship benefit, it goes to the survivorship benefit. So on my part, there were no conversations with QDRO Consultants about how to do that. In fact, the order is clear that I never said anything to them. I sent them a cover letter with the documents. I sent them a payment, and I said, please process this. That was the only conversation that I had, and that was borne out by Mr. Hogan on his direct testimony in court. So there was nothing done. Nothing was done untoward. Everything was done the regular way and the default way by us and by QDRO consultants. And everything was proper in that regard.
Thank you. Thank you, counsel. We'll take the matter under advisement. You'll be notified of our decision.
Thank you.
Our final case this morning is 2020-1521, Cleveland Metro Bar versus John Alex Morton. Respondent, Mr. Morton. You'll have to unmute yourself, Mr. Morton.
May it please the court. I would like to reserve whatever time I have left over of my 15 minutes after I make my initial points. I think that my defense to this case has always been that the remarks, the statements I made were true. And secondly, I think I have the right to speak the truth. And thirdly, I don't believe that the relator in this case, the Bar Association, had standing to bring this case since they were not the injured party. And what this case really presents is an attempt to coerce the private bar in this state to not speaking the truth. And those are the main points I want to make at oral argument. My brief, I believe, covers everything. So at this point, I would be interested in hearing, answering any questions that the court might have for me.
Hearing no questions, I guess we'll reserve what you've got left. And Mr. DeSantis.
Okay, thank you.
May it please the court, Frank DeSantis for relator. As indicated in the board findings of fact and conclusions of law and recommendations, this case involves comments that respondent made in a pleading filed with the Supreme Court of Ohio. These comments recklessly impugn the integrity of appellate judges and Supreme Court justices who ruled unfavorably against respondent's client, were degrading to the tribunal, and were prejudicial to the administration of justice. Based on the evidence presented at the hearing before a panel of the Board of Professional Conduct, the hearing panel found by clear and convincing evidence that respondent violated rules of professional conduct 8.2a, 3.5a6, and 8.4d. The board voted to adopt the findings of fact, conclusions of law, and recommendations of the hearing panel, and the sanction recommended by the panel that respondent be suspended from the practice of law for a period of 1 year, with the entire suspension stayed on the condition that he commit no further misconduct. In response, respondent raises several points. First, standing. Mr. Morton contends that since, in his view, there was no grievant, the Certified Grievance Committee of the Cleveland Metropolitan Bar Association had no standing to institute an investigation or bring a complaint against him. As relator has argued on the several occasions that respondent has raised this argument, the Supreme Court rules for the government of the bar 59C1 clearly sets forth that a grievance committee shall review and may investigate any matter filed with it or that comes to its attention. This court confirmed that concept in Disciplinary Counsel versus Oviatt. No formal grievance is required. Also, with respect to standing, respondent has also asserted that there was no injury caused by his inflammatory statements. Realtor's authority to prosecute grievances, however, is not dependent on an injury requirement. The Ohio disciplinary process exists, excuse me, to protect the public by deterring lawyer misconduct. If some injury is required, it is supplied by the damage to the public's confidence in the justice system that respondent's misconduct has caused, as indicated in comment 1 of Rule 8.2, quote, a lawyer's false statements impugning the integrity of judicial officers can unfairly undermine public confidence in the administration of justice, end quote. The board found respondent used unnecessary attacks that could negatively affect the public perception of the courts and the justice system as a whole. Clearly an injury if one is required. With respect to the violations, respondent argues that the statements which form the basis of the findings that he violated the rules of professional conduct were not false, nor made with reckless disregard for the truth. But consider his statements. The court decided Moskowitz case based on politics, not law. The political goal of the Moskowitz court was to maximize government revenue at the expense of taxpayers and his or her constitutional right. The political agenda of the Moskowitz court was the promotion of the leadership of Justice French on this court. Justices French and Kennedy thereby showed a willingness to favor government at the expense of taxpayers and the Constitution, no matter how unreasonable the government's view of the true value of the subject property. The Moskowitz court could not do so, instead intentionally misstated the holdings of each of the cases it cited. Of the Court of Appeals, Mr. Morton said, only politicians committed to maximizing the revenue of their political cronies could reach such conclusion. The respondent's comments recklessly impugn the integrity of judicial officers. He is affirmatively stating, and it can be reasonably understood to mean, that the justices of the Supreme Court made decisions based on political motivations or personal reasons and not the law. He undertook no investigation to confirm the accuracy of those statements, conducted no interviews, and testified that those statements were based only on his readings of the opinions and inferences made from the facts and the law. There is no reasonably factual basis for those inferences. There is nothing in the Moskowitz opinion of the court that supports any of those inferences. Here again, as in Gardner, there is nothing in the opinion that could lead anyone to conclude improper motivation by the justices in their holding. In Gardner, this court held that a failure to investigate constitutes reckless disregard for the truth. We cite a line of cases in our brief wherein this court reiterates that point. Thus, without more, respondent statements can only be considered at a minimum made with reckless disregard for the truth. Respondent argues, and again reiterated today, that he provided evidence at the hearing supporting his position that the court did not follow the law. Assuming for the sake of argument that was even true, that's not the basis of this agreement or the findings against respondent. A lawyer can state without ethical repercussions that a court erred in its findings, that a court misinterpreted the law, that a court got it wrong, or even that a court did not follow the law. If Mr. Morton had stopped there, we would not be here. What a lawyer cannot do without any evidence or even investigation is ascribe an improper or dishonest motivation for the court making its ruling, as respondent did in this case. With respect to the board,
would he be here if he left names out of his brief? If he just said the dissenters, would he still be here?
I'm sorry, Justice, could you repeat that?
So, understanding your argument, had he just said the dissenters in this opinion held and believe that deference should be given to the BTA, would he still be here?
I do not believe so, Your Honor. A lawyer can argue that a court didn't come to the right conclusion. A lawyer has the, I think, obligation to raise the question about whether a court came to the right conclusion.
So the fact that he names majority authors and speaks that they actually got the decision right, Is that problematic? Are you saying that they just can say the majority or the dissenters and not use a justice's name?
Well, I don't think I don't think there's a problem with using a justice's name or the majority or dissenters. I think what's a problem is ascribing an improper or dishonest motivation to either the court as a whole or individual justices.
So when he says Justices French and Kennedy thereby showed a willingness to favor the government, in other words, our deference to the BTA, he's assigning that that's in favor of the government. Why is that improper?
I think what he says, Justices French and Kennedy showed a willingness to favor the government at the expense of taxpayers and the Constitution, no matter how unreasonable the government's view of the true value of the subject property. He added pejorative words and meaning to what your decision, what your view was in that case.
So are you reading those words in isolation then? Because if you read the whole brief, he's really talking about whether or not the BTA is entitled to deference. I'm trying to understand where the line is. When you read this brief, he is talking about that the dissenters were wrong. No deference should be given to the BTA as it relates to the valuation of property. He was purportedly in favor of majority authors like Justice Pfeiffer, Justice Lanzinger, in ascribing to them that they are holding the BTA, who is a branch of government administratively, to the standard of no deference, and he's agreeing with that. So where is the line drawn? How would a lawyer know that at which point in time, as you're writing this brief, that somehow you're stepping into hot water?
Well, I think, Your Honor, in Gardner, the court set a standard for determining whether a statement is made with reckless disregard.
That was a criminal context.
I'm sorry?
I mean, maybe I'm wrong, but I thought in Garner, what the respondent did was accuse a judge of criminal misconduct.
Well, in addition to other things, that's correct. And
okay,
in this
so
case,
here all he's saying is we're getting our deference standard wrong in favor of government. And because it's in favor of the government, it's against the taxpayer. So where's that line drawn that he should know he's in trouble when Garner was really accusing a member of the judiciary for engaging in criminal misconduct, which is completely different than deference?
I think, Your Honor, the Gardner decision uses a reasonable attorney objective standard. And I don't think any reasonable attorney would view the comments that Mr. Morton made in his filing with the Supreme Court as appropriate or even helpful to his case. I think that a reasonable attorney would not use those comments. And that's the standard that Gardner used in determining whether it was made with reckless disregard for the truth.
Thank you.
Sure. I'm going to skip to the sanction. I could address a couple other points if the court would need. But with respect to the sanction, the board recommended that respondent be suspended from the practice of law for 1 year with the entire suspension stayed on condition. Relator objects to that recommendation and submits that based upon the evidence forming the basis of its complaint and Mr. Morton's subsequent conduct, he should serve a 6-month suspension. In its findings of fact and conclusions of law and recommendations, the board found and acknowledged that the respondent refused to acknowledge the wrongfulness of his conduct, was indignant and confrontational through the course of the hearing, and refused to abide by rulings of the panel, repeatedly directed improper questions to the panel, and he stated that he planned to engage in the same type of conduct in the future. In addition, the board acknowledged that unfounded attacks against the integrity of the judiciary typically require an actual suspension from the practice of law, and that the case law supported relators' position that respondents should serve a 6-month suspension based on this court's precedent in Proctor and Gardner. Despite respondents' conduct and the precedent of this court, the board held that a 6-month suspension was not warranted, but should be more in line with the sanction imposed by Shimko. Rather than reiterate all of the arguments we made in that brief with respect to Shimko, let me make 2 key points. First, distinguishing Shimko's conduct from Mr. Morton's conduct. Shimko's comments were made about one judge in a common pleas court. If members of the public learned of and believed Shimko's comments about that judge, it might not translate to a lack of confidence in the entire judicial process. Mr. Morton impugned the integrity of the Supreme Court of Ohio, the highest court in the state. If members of the public learned of and believed Mr. Morton's comments, that might well lead to a lack of confidence in the integrity of the Ohio judicial system.
How would anyone learn of this? This is
I'm
just,
sorry?
How would anyone really learn of this? There
Well,
are
Your Honor,
hundreds of jurisdictionals filed in our courts all the time, thousands and thousands of documents filed in courts around the state. How would anybody know of this other than our own publication of it here?
Well, Your Honor, I was just going to make the point that it is accessible on the Supreme Court website right now with a description of the comments that Mr. Morton made with respect to the arguments that are before the court now. There are media who pay attention to Supreme Court decisions. There are media people who read briefs that are filed with the Supreme Court. There are lawyers who talk about what happens in the courts and what arguments are made to the court. There were several lawyers involved in the Moskowitz case, and those lawyers could well have talked to other people, including their clients, and their clients were involved in the Moskowitz case. The Moskowitz clients probably read those briefs, and a ripple effect.
Well,
Do we worry?
Well, wait a minute. That being true, you're still talking about a very small universe. I mean, I don't read newspapers, all the newspapers across the state. I don't remember this being a big issue. Clearly, I think judges are attacked during election cycles for being politically biased or in favor of one side or the other. As you stand witness to what happens in 19 or 2020, nobody talked about this case. So where is the big broadcast of this?
Your Honor, I don't believe as lawyers, we want to allow fellow lawyers to impugn the integrity of our justice system because nobody will find out about it. I don't think that should be the standard. I think the standard should be that a lawyer should be professional, should honor the courts that they serve in front of, and not impugn their dignity. And I think that was the purpose for the rule that was established by the Supreme Court. And I think that Mr. Morton almost certainly in everything he said violated that rule and those rules. I'm sorry. I'm out of time. I had one more conclusion point to make on the sanction with court's permission.
Proceed.
The second point I wanted to make is the board recommended that Mr. Morton be suspended from the practice of law for 1 year with the suspension stayed in the entirety on the condition that respondent refrain from further misconduct. Despite this admonition, the very first words from Mr. Morton in his brief to this court that followed that report in this case is, quote, "This attorney discipline case is about law cases being decided on the basis of politics and not the law." Further, in his brief, he goes on to allege that the board's findings of fact and conclusions of law were also based on politics and not the law. Mr. Morton clearly has no remorse for his conduct. He is all in, and this court should be as well. Thank you.
Thank you, Mr. DeSantis. Mr. Morton? We'll have to unmute Mr. Morton.
I want to reiterate again, all my statements are true. And
let me ask you about that, Mr. Morton, because it's interesting. I couldn't help but observe your body language when opposing counsel was speaking, you didn't seem to be listening and you were smirking. And so is it your position that every time you receive an adverse ruling from any court, it's not the result of, a difference of opinion on a matter of law? It's really just because the whole system's corrupt and this is what you have to face every day? Is that your position?
Well, first of all, you said I was smirking. I wasn't smirking, so I don't know why you would
Okay,
say.
let's just get to the substance of my question. Is that your position? That the whole, anytime you receive an adverse ruling from a court, it's not because maybe the court interpreted the law differently than you did. It's because of, just the improper influences in the court and politics and result-oriented analysis, and it's just corruption. That's your opinion?
Justice Donnelly, I've made it very clear in my briefs all throughout this case that this court did not follow the law in Moskowitz. That is my issue. It has.
But you did more. But you did more than that. There's nothing wrong with saying that you came to the improper. This court didn't follow the law correctly. That would have been fine. You wouldn't be here today. But you suggested that it wasn't just incorrect analysis. You ascribed as a lawyer in a filing that it was the result of improper influences. Right.
I said that it was a political decision designed to maximize revenue to the government. Yes, that's correct. That hasn't changed. It's not a matter of me losing a case. It's a matter of this court not following the law. I can go into great detail about how the court didn't follow the law in Moskowitz. I don't think anyone here is asking questions about that. But for example,
Counsel, what's the improper influence? You are not saying that we have a intellectual difference here. You're saying that there is improper influence on the justices of the Supreme Court of Ohio who decided Moskowitz. What's the improper influence? The improper influence is a political one of maximizing revenue to the government. And all right, stop right there. Stop right there. How do you know that? Because the decision in Moskowitz was so far from the law that it's not based on the law. The natural implication of it is that the tax revenue was enhanced. There's a constitutional provision in this state. Counsel, you couldn't make an intelligent legal argument. You had to resort to ascribing improper influences to the justices. Is that what I'm to understand here? That your inability to issue a convincing, intellectual, legally based argument was beyond your capacity, and therefore impugning the integrity of the members of this court was your only resource or recourse. No, I've made a very coherent and accurate argument regarding the law, Justice O'Connor. For example, the decision which you signed on to said that the Moskowitz's burden shifting theory is refuted by the case law. It's not Moskowitz's burden shifting theory. It's a theory that was over 100 years old, first brought out by Thayer, professor at the Harvard Law School. So you've changed the entire law on the burden of proof in this case, all right? And it has to do with real property tax cases. Real property taxation in Ohio is limited by our Constitution, Article 12, Section 2. So yes, that's precisely what I'm saying, is this was done for political purposes.
many of you are political figures. Yourself, your Chief Justice, the reason you came to Ohio-wide attention was because Governor Taft named you as the lieutenant governor, and that spread your name over to the state of Ohio, and then you were able to run for Chief Justice or Justice of the Supreme Court. That's why your name is out there, is because a politician with a very powerful name in Ohio, Taft, appointed you. Justice DeWine sits on this court. Justice DeWine is the son of the current governor, who's been a career politician. Everyone is living off the taxpayer's dime, salaries, pensions, benefits. So yes, that's precisely what I'm saying here. If the decision had been based on the law, we wouldn't be here.
So Mr. Morton, the way we are employed, the way we earn a living, the confidence that the voters in Ohio have placed on this panel of judges is only there because of a political consideration, in other words, names, and not confidence in our abilities as jurists.
Yeah, I think that basically we've got a name game here in Ohio. I don't think the average voter has any idea of your judicial philosophy. So yes, that's true, and that's very
Mr.
true.
Mr. Morton,
yeah.
Do you remember the oath you took when you were sworn in as an attorney? Do you remember what that is?
I may have forgotten it, but I mean,
well, part of it is to show respect to judges, right?
Justice Donnelly, you took an oath when you were sworn in as a justice to follow the law. Okay?
Right.
The law was not followed in Moskowitz at the expense of the taxpayer. We have a constitutional provision of free speech in the state of Ohio. By encouraging this prosecution, you are not following that law. You also took an oath to follow the law, and I would urge you to follow the law by
attorneys very often tell me that they don't think in my decision making that I did follow the law. If they disagree, and that's an attorney, as your opponent pointed out, has an obligation to point out when that takes place, and I have no problem with that. But you know, I show respect to attorneys, and I expect attorneys to show respect to the court and the process, and there's reasons for that. It's not just because we think it's a good thing to do, because as a profession, we want the public to have confidence that the court is independent and is free of all these things that you are suggesting motivate our decision making, which is just absolutely incorrect, and which you have not provided any evidence to support.
I think I provided the evidence, Justice. You just apparently don't want to hear it. We have a constitutional provision in the state, Article 12, Section 2, that limits property taxation. No one, and no one has mentioned it. No one has dealt with it. So you are ignoring the law, and that's a violation of your oath.
Counsel, let me ask a question.
Yeah.
There's a couple statements in the report. One about, quote, the most obvious evidence of the nature of the Moskowitz decision was the decision to delay the decision until Justices Pfeiffer and Lanzinger retired from the court and were replaced by Justices Fisher and DeWine, close quote. And the other is, quote, responsibility for the delay must be assigned to Chief Justice O'Connor since it would not have been tolerated without her approval, close quote. What evidence, factual evidence, do you have about the delay?
First of all, there was the delay itself. Why was the decision delayed until Justices Pfeiffer and Lanzinger went off the case? There was over a 1-year delay in the decision of this case. Okay.
No, that's a question you're asking. Why? I'm asking for your evidence.
And my evidence, the reason I drew that inference is that Justices Pfeiffer and Lanzinger favored my approach in the Schwartz and Ross cases, which I won at the Ohio Supreme Court. And so by waiting until they were gone, the two new justices came in, yourself and Justice DeWine. Personally, I think you were blindsided by this, that you didn't know the history of it. The history of this is there was a dispute between Justices Pfeiffer and Justice French regarding deferring to the Board of Tax Appeals or not. It came to a head in the Akron City Schools case, and I would urge you to review those cases, take another look at them, because the law here in Ohio is not being followed. People are being overly...
Counsel, we know that you don't agree with the law. Let's just put that aside. We're asking, or Justice Fisher and I'm interested in, your basis for making these decisions, making these accusations. What was the time between the filing, the briefing, the scheduling, and the other considerations that this court makes when we schedule matters for hearing?
Are you suggesting, Chief Justice, that there wasn't a delay?
I'm asking you. You tell me.
The oral argument on that case was in December. The written decision did not come out for over a year and 3 to 4 months later in May. That was an unnatural delay, okay? It's all in my brief. The other cases that were heard, at a similar time were decided earlier. And why did
Counsel, are you saying that Justice Pfeiffer and Justice Lanzinger heard this case?
No, they obviously didn't hear this case. In other words, the decision was delayed. The decision was delayed until they left the court. I wish they had heard the case. And the reason I attribute the delay to you is, as the Chief Justice, I believe you have a lot to say about scheduling. Okay.
So Mr. Morton, apparently I'm clairvoyant, you know, and I've never been accused of that before. But so I'm clairvoyant, and I would delay this because I knew that Justice DeWine and Justice Fisher would be elected. I would then prefer their perspective on something like this rather than my former colleagues, Justice Lanzinger and Justice Pfeiffer. And that's how I operate. Is that what you're saying?
I'm saying that Justice French's view that you defer to the Board of Tax Appeals, even on questions of law, which is clearly wrong, you were brought over, you came over to that point of view. Now, you couldn't have done any worse than having Justices Pfeiffer and Lanzinger on the court, because you knew what their position was. Their position was that you don't defer to the Board of Tax Appeals on questions of law. So therefore, when Justices Fisher and DeWine came in, you couldn't have done any worse, okay? And also, as new justices, I think that they would be more under your sway and the sway of the senior justices on the court. And then also, so Justice O'Connor, Justice O'Connor, if what I've done was so terrible, why didn't you file a grievance?
Oh my God. Okay. Any other questions for Mr. Morton?
Why didn't you file the grievance?
All right. We will take the matter under advisement, gentlemen. Thank you. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.